Hi, everyone. Welcome to our new season of webinars here at Lumaprints. It's been a while, I would say approximately a month since we last met. In the meantime, we gathered some new topics and things that might be of interest for you as customers. We also have in the works some webinars that will be product highlights. So if you're interested in any of those, feel free to make sure you're subscribed to our newsletter, or you could also make sure that you're also subscribed to our YouTube channel. There you can see all our previous webinars and then as well as any other video content that we provide later in the future. Nonetheless, thank you guys for joining us. Today's topic is kind of a big topic, I will say, or at least one that I think is fairly important when you're starting your business. And even if you've been in the business, it doesn't help, it doesn't do any harm to kind of pick up on any stuff that we talk about today and take notes. Of course, I will be linking some articles in the YouTube channel afterwards relative to this webinar because one, this is a very informative, heavy topic, um, specifically within copyright and other type of you know, legal legislations and things that come to print on demand. It's a topic that I find either you know a lot about it because you've had experiences with either copyright infringement or you yourself have been dealt a really bad contract, and so there is a lot of things relative to a print-on-demand store when it comes to the legal challenges and copyright and things of that sort. Nonetheless, I do want to clarify and be very, distinct that we are offering what we found through our research, and a lot of the stuff is through articles, and it's while informative, it is not going to replace legal counseling, and it's not going to replace, anything that a lawyer would provide. So, of course, if there are some questions that are specific to your situation, we can try to offer some suggestions. However, we cannot do the same that a lawyer could do, which is provide counsel to a very in-depth degree. So keep that in mind going into this. We just wanted to bring forward what we thought brought from our research and also things that we do find important for you to understand and know about as you go into either selling your own art, working with others, creating contracts, and understanding also the nuances of businesses and also utilizing other people's iconography or intellectual property. Um, I think that overall, it's a very complex issue when it comes to copyright. I'm sure that as print-on-demand sellers yourselves, there are a lot of things to navigate, specifically if you sell art that might be influential or might take from copyright from other places. And sometimes people don't even know that they're taking copyright or they're infringing on copyright. What I've noticed is that people don't find out until, well, someone says, you're using some copyrighted materials, and then it becomes a legal kind of situation, in which case, some people learn the hard way, if you will. Here, we kind of want to cover things and take quote unquote preventative measures to make sure you don't enter those situations where you either pay fines or have to go to court. It's not a pretty situation ultimately. And I guess speaking further into the complexities of copyright, at the end of the day, it does benefit you when it comes to copyright, especially as smaller sellers. You want to protect your IP, your own branding. You want to copyright things that to you make sense for you as a person who might have their own ideas, even own strategies on how you present your website and things of that sort. There's a lot of things that you need to protect for yourself, but inadvertently, that also pays to mind with things like, for example, one big company that comes to mind that lives down our block is Disney. And when it comes to Disney, they're very influential. A lot of their art and a lot of their movies have great impact on people. However, when it comes to the copyright, it becomes difficult because, people might be inspired by it, but it's really hard to sell then art that is inspired by it if it's too on the nose, if you will, or too much of an imitation, quote unquote. And even then, that becomes very debatable. But most people just say, stay away from Disney IP property. And as you all know, it's a pretty big monolith. So they own not just their own movies, but they own ESPN and news networks and things of that sort. So, um, sometimes copyright can be to the detriment of a lot of artists and a lot of business owners because even if you want to take inspiration from such huge influential pieces, there are legislations put in place to protect those big IPs and big properties. But in turn, they do help you at the end of the day as well. When it comes to the importance of complying with intellectual property laws, first I want to talk mainly about intellectual property and what is considered intellectual property. And this covers a lot of things and it helps you navigate as well when you decide to go into, what you can and cannot use, what can you skirt around. But overall, they distinguish IP or intellectual property as literary or artistic works, images or photos, slogans, trade secrets, organizational practices that are very unique to them or copyrighted by them, of course. Um, Computer programs and databases that are theirs and made by them. Architecture and installations, kind of under the same idea of artistic works. Music that includes lyrics. And then, let's see and sorry, that one's covered, designs and inventions. So there's a lot of categories, and of course, take this with what you will at your discretion, but just note that, when it comes to IP, all of these categories are considered IP. And we'll talk about the differences between these and also trademark and trade dresses. Um, but for now, understanding the importance of complying with these property laws and also complying with copyright is very important. One, you don't want to face a lot of fines, possibly, especially if the person or company that you're inadvertently, consciously, or coincidentally taking items from will decide to take you to court. It might become, if anything, expensive. You don't want to pay fines nor do you want to have legal counsel to pay for because of this whole deliberation. So overall, there is a monetary risk with infringing on someone's copyright or taking someone's intellectual property, whether you know or not know. That is not really up for debate in the court. It's more so what is considered you taking their stuff, and that's going to be debated. It's not necessarily about the consciousness of doing it, but rather, are you doing it or not? And that gets debated in court. So ultimately, if you are found to be using their copyright items or intellectual property, you can be fined, and that's not good. Ultimately, legal battles are never good for a print-on-demand business. It's not good for you. It's not good for your bottom line, and it's not good for your ease of mind either. Um, so keep that in mind. I know that what a lot of people tend to do, which I don't necessarily recommend, but what I've seen is that people will skirt around these intellectual and copyrighted materials and put the logos or imagery there until they run into trouble. Um, I just say be very careful about how you decide to go about that. Think about how some people like to use fashion logos for their prints or use icons that are copyrighted on their prints because, ultimately people are very creative with how they decide to reimagine these icons or these properties. But then it gets into much more complicated territory when the person who owns that copyright decides to, kind of pursue a case with that. And it's not ideal ultimately. And then understanding copyright in general for designs and art. Note that there was a law passed specifically in 1978 that allowed for copyright to last for the life of the creator plus 70 years at the point of the inception of the material. Of course, if you take things, if you want to be very, clear and cut about things, it's worth taking it with the Copyright Office here in the US at least, and making sure your items are copyrighted under the government. It's not really saying that they hold your copyright as tried and true, but rather they acknowledge that you have copyrighted something. And copywriting something with the government is just acknowledgement, not necessarily them protecting it for you, but you protecting yourself because it's at least acknowledged by the party being the government. Um, and with that being said, whenever you create a piece of work that is unique to you, it is considered your own item and your own copyright, regardless. So, what I would always suggest to customers or people, regardless, if you are posting art online, for example, which is part of print on demand, is to always include the copyright logo, your name, and the year, or the year and your name. What this does is it lets customers and people who are viewing your art know that it is your property, it is yours, you made it. It might not always look the prettiest, but it's worth putting it on online images. Of course, if you sell your art, you don't have to include it there. Um, I know that it's not the prettiest thing to have a piece of font or some writing in the bottom corner every time. So as long as it's on the online material, it doesn't necessarily need to translate into your physical product. But I thought it'd be very important to make note of that because sometimes people will take art, unfortunately, and claim it as, well, you didn't copyright it. I don't know who the owner is. It was on your website, but there was no sign of ownership because there was no, copyright logo with your name and year. Um, and so keep this in mind, protecting yourselves. I know that a lot of artists is, in this day and age do fear about their art being taken because of how accessible it is online. Back then, if you wanted to duplicate someone's art, you would need either the original, come across the original physically, take a picture, and even then, like, can a picture really replicate a duplicate as well as anything else? That's up for debate, but ultimately, nowadays, because of the internet access and how we post our art to make business, people in turn can use your art, unfortunately. Another way, this is kind of an aside, but another way you could prevent people from taking your art is also just making sure that whatever front-facing online images you have are low quote unquote quality. That is, they're meant for web, but they're not meant for printing. Usually this means 72 DPI, medium size images. So try not to go more than 1,200 by 1,200 in pixels. If you get any larger than that, then it could serve to be good quality for someone to actually replicate it for a print. Um, of course, including a watermark is also a great way to go, either with your name or even, like I said, putting the copyright logo and also your name and year. Um, but those are some ways that you can prevent art theft or people taking your art and reusing it for their products. And then ways to avoid copyright infringement. There are a couple ways that you can avoid it just as a preventative measure. If you are like me, very cautious, you just want to make sure that you don't have to run in with any situation where someone will be saying, hey, that's my art, or hey, you're taking from me. I would say just start from scratch. Any art piece that you do, start from scratch. Or at the very least, I know there's some collage workers, for example, that becomes very complicated. As long as you can really transform the piece to the point where it's considered fair use, where it's very distinctive enough that you can't really associate it with the original piece, you should be pretty good to go. Say you use scraps from magazines, make sure that whatever scraps you use don't fall in line with copyrighted material. So if it's logos, iconography, or company slogans, make sure that you remix it enough that where if people can't necessarily say, oh, that's this company's brand, or oh, this is this designer's, clothing. Um, Transformative works are debatable, but again, best practice is to definitely start from scratch. Another thing you could do is definitely research before you start creating, before you put in time and effort and, overall just creative effort to make the piece. Make sure that what type of ideas you're coming up with haven't been done before to the same point where someone could possibly say that, one is copying the other. And that's really hard to think about because, one could say there's so many designs in the world that someone can make, and there's so many people out there. There's bound to be two people making the same piece that's very similar. Of course, I don't think there's copyrighted parameters to say copyright, for example, a woman in a red dress. But there should be enough if that woman is holding a Coca-Cola bottle. So consider like, messing with ideas, making them distinctive enough where they won't fall under copyright. And even if you're not 100% sure, or you're like, oh, well, no one would ever make this idea, consider just Googling whatever idea you have in mind and just seeing if anything pops up. And if something does pop up, consider, while you like that piece, see how you can do it differently, or what things can you do to kind of step away from that piece and make it distinctively your own. But that's just some, things that you can do preemptively. Finally, if you are inspired by something enough to want to create something as a response in conversation with, as an adjacent or complementary, just make sure that it is inspiration only. Tracing, drawing, piece by piece to the exact type, that becomes very it could lead into some court cases if it goes to that. And it's not all the situations, but again, if you want to play it safe, do so. And I definitely suggest just making sure you're one is being inspired and not imitating. And again, going back, make sure you research priorly and make sure that if you are going to start with something, start from scratch with your own materials. Um, I know for some folks, what they like to do as artists is they like to use stock photos for references, or maybe use that as their underlying base before they start implementing their own art style or drawings or textures. Just as long as it's distinctive enough where you can't even recognize the original stock photo or original copyrighted material, you should be good. But again, what one person considers as distinctive enough might not be the same for someone else that is the copyright owner. As for navigating licensing agreements, this is more so a conversation not for the court, but more so for you and potential collaborators. And so there are some key elements to keep in mind when it comes to licensing, and also how to navigate what is considered under contract and not under contract. Um, if you ever license your artwork, you might be familiar with some of these ideas. And if you are a business owner interested in licensing your work, um, just note that these are some pointers that I've seen that are very useful to keep in mind. Um, Also, it's worth also seeing and doing more research into this because it's a really big topic, and I'm just trying to cover the overarching basis of it. But hopefully, with this, it's a good business endeavor at the end of the day. So hopefully, with this, you can take with this and kind of start the beginning steps of maybe licensing your work. Because if you own some really cool art and you have a store, but you want to get more business or create a second streamline of income, licensing artwork is actually a pretty lucrative way to do so. So, first, I want to kind of talk about the parties involved, which is the licensor and the licensee. So, with the licensor, that is the copyright owner who grants the license, if you will. Um, they're the ones who are kind of going to set the ground rules, but also doesn't mean that a licensee, the person who is going to be receiving the license of to use artwork, doesn't have any, say in the matter. It's just a matter of the licensor does take precedent when it comes to making contracts. Ultimately, it is a contract that both parties will agree upon, and it's basically an exchange of like how you're going to offer the piece or the creative material to to the parties involved. And so, when it comes to licensing agreements in general, there's various types of agreements. Specifically, let's talk about exclusivity and non-exclusive. So with exclusive licensing agreements, this means that only the person who's licensing the work is going to be able to use that work. Not even the owner themselves, that is the licensor, can even use it, only the licensee. Um, they will be the ones that could do what they want with the piece under the contract, of course. That is to say that if you put in place that I don't want you to sell my art to a specific company, you can do that. But you have to make sure that your contract is very thorough if you are going to provide exclusive licensing. One, because oftentimes with exclusive licensing, it can lead sometimes to, unfortunately, some contracts that are not as power balanced as I would say non-exclusive licenses. So when it comes to exclusivity, if someone is going to ask for exclusive rights to your piece, it is going to cost a lot more than non-exclusive, just to keep that, in mind. I would say charge double, if not more, than you would with a non-exclusive contract. I would also say put a timeline on it. Don't make it indefinitely, as well as being very careful on how you decide to give exclusive license. If you're okay with the artwork no longer being yours and not being something that you will share with other people, then by all means do so. But if you're very much a person who really wants to own their pieces and not have people, own it, if you will, to the same degree as someone with exclusive rights, then I would consider non-exclusive licensing agreements. And with that being said, I think that you still need to take a lot of procedures and cautions when it comes to making a contract with someone with non-exclusive licensing. You still want to make sure there's a timeline. You want to make sure there is clear and defined lines of what you are okay with them doing with your piece. So say you're okay with them creating artwork of it, that's fine. But do you want it on a greeting card? That's a different conversation. And so there are things that you need to be very distinct about in a contract, and you can't leave it open-ended. In fact, if you have hard nose with your art, then you need to be sure that you outline that in your contracts, regardless if it's exclusive or non-exclusive. Um, Also keep in mind that going down the list, when it comes to fees and royalties, that's also laid out in the contract. So how are you going to get paid? There are different ways. I think I've seen combinations of fees and royalties. Things like a base pay of to own the copyright, and then secondly, you get royalties as a bonus. So say, the base pay for non-exclusive right is $500. They pay you the $500, and then with every subsequent sale, they have to give you a percentage or a dollar amount. That's what royalties and fees might look like for you. It could be just one where it's just one base payment and then they have it for a year or 2 years, or optionally they get the licensing, but as so long as they pay you a small fee every time someone purchases that piece. Um, so there are different ways and methodologies behind every licensing agreement, and they're not going to all be the same for each company. So if you've been in the licensing business or have licensed your art before, you know that, sometimes what works for one company in terms of how you want to license to them might not work for a different company. So keep that in mind going into these contracts, because these are things that could either be really great, or they could also kind of be unfortunately parasitic or take advantage of artists who might not know enough about contracts. As you probably know, there's artists, musicians also who enter kind of bad contracts that takes away a lot of their rights but doesn't give them enough compensation as return. So that is also applicable, unfortunately, to artists who do art or sell their art online. Just be sure that you are well aware of what's in the fine print and don't leave any stone unturned, if you will. Um, of course, payment schedules should be also acknowledged here. You don't want them to be always late on payments and then there not being a contract that indicates, when they should be paying. Because if you just say word of mouth, you're going to pay me every month, and they don't follow on that, it's hard to take them then to court to discuss that they have not been paying you if that payment schedule was not defined clearly in the contract. Um, and of course, always have it in writing. Things should never be word of mouth. Things need to be laid out on paper. So you, them, and also if in worst comes to worst, a court needs to see the agreement, it is there on paper. Kind of pivoting from, I guess, licensing, I just want to also give you guys how you can do preventative measures of safeguarding your original designs and also making sure that, you yourself don't come into having your art taken or, duplicated in some way that's too similar. As we discussed previously, the copyright logo, watermarks, lowering the value or, sorry, lowering the quality of your images online are all beneficial. Another thing to consider is NDAs. Overall, NDAs or non-disclosure agreements are things that let you know between you and your parties involved whenever there's licensing involved or contracts that things will not be spoken outside of your party. So I would say, if you want to, with every licensing agreement, there should also be included an NDA, and that should be between you guys, as well as other art pieces and all their nuances, such as strategies that you do for your store and things like that. Say you work with an app, for example, that helps you with your, um, say you work with an app that works with you know, your storefront or your images. Consider reading into their disclosures and making sure that they themselves are not using your art for other purposes. If you read their terms and conditions and other material, the fine line, if you will, it's worth reading it because online, unfortunately, we use and work with a lot of other companies, especially with apps and things that help you with your business. You want to make sure that they're not using your information or your imagery to their own benefit or giving it to other competitors. Unfortunately, if your state doesn't have safeguards, people could write in the fine print that we have a right to use your information, or we have a right to use your customer list, or a right to utilize your information for our advertisers. Um, if as I don't know if you guys are aware, but because a lot of the online space is free, um, by monetary means, unfortunately, our data is not necessarily um, safe because, if we're not paying money to use a program or use an app, we're paying by other means. And usually data is another way that companies take from the consumer. And that data can be, something as meaningless as your name and location, but it could also be as intricate as what is this person's purchase history or what is this person's um, images that they're selling online. So you want to be very careful and making sure whenever you're reading the fine print with other companies that you're working with, to make sure that they're protecting your rights and protecting your designs. With Lumaprints, whenever you upload an image with us, that is exclusively yours. No one else sees it besides you and us here at the company. We don't give it to any data breachers or any data companies. Your images are protected by us, as well as your customer information that is protected by us. So at least you can be safeguarded with us, knowing that when it comes to other companies, you do want to make sure that you are reading the fine print for them and also making sure that they're having your stuff and your materials in your best interest. And then when it comes to trademark and trade dresses, there is a distinction between the two, and I kind of want to cover those two as well. When it comes to trademark is specifically safeguard logos, names, designs that signify the origin of products or services. So you should be able to easily differentiate between what is a trademark that's offered from one company over the other. Um, Overall, trademark can be things, that you see as I'm talking back about Disney. It'd probably be the Disneyland font and also the name itself, Disney. So though that's just a small example. Whereas trade dress is a bit more nuanced and a bit more underlying. When it comes to trade dress, it's the overall visual appearance and presentation of products or businesses. This can be like the shape of a Coke bottle or the arches of McDonald's, things that are not intuitively when you think of McDonald's, those, but if you were to see that somewhere, you'd be like, huh, that reminds me of Coca-Cola or that reminds me of X company. Um, and they kind of have the quote unquote secondary meaning that is on their own, they might just be a Coke bottle, they just might be a glass bottle. But the secondary meaning is that they are a Coca-Cola bottle because no one else has that shape to them. Um, I think that what is considered trade dress is how many marketing efforts they put into associating one item next to their company. So while it might not be exclusive to them, if you decide to sell something similar and also somehow coincidentally use their stuff that or their iconography or their trade dress, then that could lead to some repercussions. So trademarks are a bit more defined, a bit more clear cut, whereas trade dress, it's going to be a bit more, I would say, two-layered. The first layer being this is just a product or this is just an item that anyone could use. But if you combine it with some other aspects, you can easily go into the infringement territory. And then when it comes to terms of service and privacy policies, as I talked previously, it's very important to know about how your data is used. And also, it's important to know how your customers' data is going to be protected in your store. So as much as you want to see your products or your website protected from data breachers, you also want to make sure your customers' data is protected when they're navigating on your website. And one of the ways you can do it is making sure you disclose everything you know in the terms of service disclosure and privacy policies. And these are two different things. They are mandated by law, so you should have a terms of service on your website regardless. And this will let them know what are the things that you'll be taking in terms of information from your customer. Are you just taking their name and address, or are you also taking their search history and things of that sort? We've had many webinars where we talked about tracking your customers' behavior on your website. And it's very useful, yes, but also make sure that you're very clear and cut and dry about this, because if you're not telling your customers first and foremost that you are tracking their information, another way they kind of say it that's not as obvious is that they're saving your cookies. And by that, they are looking to see what type of information you're interacting with on their website. And so make sure that you, one, offer a disclosure that lets people know that they're being tracked. And two, what's just good practice is giving them the option to opt in or opt out of that. Um, Most customers receive well when they are given the option, and usually they just accept all anyways. But if your customer is very particular about not having their information tracked, it's good to have a terms of service that highlights that and also having permissions available for them. Um, of course, if you don't have this, this could lead into some repercussions because it is mandated by the law that you need to have a terms of service that clearly outlines what information you're using. I know that with California in particular, I think we're one of the first, if not the first state that really mandated this. So if you live in California, you will definitely get a little permissions note on every website that you visit, essentially, that lets them know that, we're tracking your information for business purposes or for whatever purposes. And so while we have that here in California, right now in the rest of the US, it's still kind of a work in progress and see who's implementing it. But at the very least, as a basis, terms of services highlighting that information is mandatory. Doesn't necessarily mean you need permissions. That's only California as of now. And I think they might be other states that are following through with that. As for terms and conditions, this kind of lays out kind of the rules and guidelines on your website by your users and for you yourself as well. While this is not necessarily mandatory, this is to protect you more than anyone else. In your privacy policy, you're more likely to see, you have the right to look at my artwork, but you do not have the right to, take this artwork and, post it elsewhere. Or alternatively, you have the right to purchase from the store, but you don't have the right to sell my art thereafter. So here is kind of where you'll lay down ground rules for, any viewer coming onto your website to know that what they should and should not be doing. Now, is every customer going to be reading the privacy policy? No. But if a customer decides to, take your artwork, post it online without your permission, and you're very particular about that, then with the privacy policy on your website, you kind of safeguard yourself from, being able to then pursue this as a case, because you could definitely say, hey, I have it on my website. It is part of my rules when you enter my website that you do not take this image and put it on somewhere else. And And then there they'll be able to, from there you'll be able to create a case for that. But if you don't have a privacy policy that indicates that, someone can't take your art and post it online, then someone can, and they have the legal means to, and you can't really pursue it in court as strongly as if you had the privacy policy in place. And when it comes to terms of service and privacy policies, there's a lot of drafts and samples available online. And feel free to use those as kind of a work in progress. But I would always say make sure you include everything, be as informative as possible, and even speak with legal counsel to make sure you know what to do and what not to post on those terms of service or privacy policies in general. And so you want to make sure that all of these are very clear cut on your website. Terms of service, remember, is mandated. Privacy policy is not mandated, but is highly suggested. And from us, we sincerely recommend to have privacy policies put in place on your website. And then, of course, ensuring compliance with e-commerce laws, as we previously discussed, just making sure that your user data is well in place and well outlined to your customer so they know what you're doing with their data. Um, if you decide to do whatever, as long as it's indicated in the terms of service, they should be good to go. And then from there, if someone is prudent enough, they could read it and disagree or agree and move on from there. But at the very least, it's outlined there. Another thing to also keep in mind in terms of the logistics of working with customers on your store is to make sure that you have a very secure payment process. And this usually helps when you have gateways like PayPal or Visa or secondary things like Shopify's payment options. But say you have your own website that is not made with any other platforms and it's your own, consider making sure that you're creating gateways and tokenizing customers' credit card information or just payment information in general to make sure that they are safe when it comes to making purchases on your website. Not only is this good for you and good business practice, but the last thing you want is for there to be a data breach and your customers' information being, compromised. Because it's one thing to take people's emails and names; it's another thing to take people's credit cards. So make sure that that is something you to pay close mind. Luckily, if you work with Etsy, Shopify, WooCommerce, or any other websites, their payment security is pretty top notch. You just want to make sure, one, that those gateways are legit. If you use any apps that offer payment gateways, make sure that those are legitimate and those are not known to have data breaches often or at all. Um, just keep in mind that there should be at the highest security is at the checkout and payment option more than anything else. So if you're going to look into security for your website in terms of data, make sure payment security is top of the line and at its best. Oop, sorry about that. And then overall, just building a legal framework for your business in general is a good practice. This is kind of my last topic, but after all that we talked about today, we did talk about multiple stuff, and I know it seems overwhelming. Feel free to rewatch this video a couple times, but big takeaways. You want to make sure that you know what is copyrighted and know how to create art that is either inspirational, transformative enough, or original where it doesn't imitate any pieces. And you could do so by making sure you do research preemptively to make sure that you won't be running into hot water should you decide to take inspiration from something. But if you decide to do something original, make sure that also the idea hasn't been brought out before and you will run into issues where people will, accuse you of, imitating or taking someone's art. The next point is to just make sure that when it comes to licensing agreements and, creating contracts with people, if you decide to sell your artwork or take artwork from someone else and, put it in your website, just to make sure that your contracts are very balanced and that both people benefit from it either monetarily or benefit from it by using that person's artwork in general. You want to make sure that it's very well thought out, very in depth, because last thing you want is to have an overarching contract, but there are some things that people can quote unquote read in between the lines and take advantage of. So you don't want to do that. You want to make sure you're as thorough in those contracts as possible. The next thing is to make sure you distinguish between terms of service and privacy policies, and making sure that you and your customers are on the same wavelength when it comes to what type of information that they are allowed to use, and also what information you're allowed to use with them, and they are reassured that you're very transparent with that. As I stated before, terms of service is legally mandated, whereas privacy policies are not, but they are very useful for you in protecting your website and your pieces. And then lastly, just making sure you comply with e-commerce laws, either local to your country or local to your state, making sure data that is shared and data that you use from your customers as well documented there, as well as making sure that payment information is very secure and letting customers know that their payment information is secure to the best of your advantage. Um, Overall, there is a lot to cover with these, and if any of these things come to interest, I will, in the YouTube video, link the government website for copyright, which is really worthwhile reading, especially if you have specific questions with your own situation. Ultimately, that's a great resource, but I understand it's very wordy. So in that case, if your business is at that level where you might run into any of these challenges, then it's worth probably doing a legal counsel or working with lawyers just for a small amount of time, at least to drop out things that you find important, and you can kind of get that in line. Creating kind of a checklist of what you want to prioritize in that sense, and then bringing it towards a legal counsel. That's just one way. Um, I'll also link another article that kind of talks about specifically, which, this is just further supplemental reading if you found this kind of topic interesting, which I certainly did. But there was a topic particularly about how Steamboat Willie Mickey Mouse is now part of the public domain and what that means for Disney and their private intellectual private property. Sorry. If that is of interest of you, that's worth a read, and I'll link that as well. That just talks about how Steamboat Willie's Mickey Mouse is now part of the public domain as of 2024, and how that is, kind of creating a conversation around intellectual property and what happens when the intellectual property's copyright expires, if you will. Um, but yeah, if that is of interest of you, we'll check out that in the YouTube video. I will see you guys in a couple weeks, but do let me know if you have any questions for now. Just to reiterate what I said at the beginning, I am open to helping you guys out with some questions, but just note that my answers will cover as much as I can, but I am not a lawyer and I can't offer legal counsel. This is just more so for any of those who are curious or maybe those who have overarching questions. So I could take those now. Thank you, India. Thank you, Tovo. We always appreciate you guys coming to these. But if there are no questions, I could end the webinar now. What I always tend to do is I leave the uh, chat open and still running. I just stop the presentation and we'll still be around for a couple more minutes. We always upload these videos onto YouTube, and we also have previous webinars on there if you're ever interested. But if there are no questions, I'll see you guys in a couple weeks. So thank you for coming. Bye-bye.